So today we'll be talking about drafting of moot memorials. So to introduce the topic, we'll basically discuss what's the significance of a moot memorial and mooting in general as well. So in law school, we've seen that most law colleges actually have intra-moots which are compulsory for students, which shows that mooting as a competition and as an exercise in itself is something that is essential for the growth and development of a student. This mainly helps in two things. One is learning research skills and drafting skills. And at the same time, it prepares you for a career in litigation later on because you've got the hang of actually drafting a memo, researching to find points relevant to your memo, as well as speaking in front of a bench and answering their queries. So with respect to that, the significance of a memorial as such in a moot competition is that it is your written submission which is actually going to be used to portray your points in front of the bench before which you're arguing. The main point of having a memorial in written form is that your arguments don't go beyond the scope of what you have actually pleaded in your written submission, as well as the fact that when an order or judgment is passed or the bench asks you questions, it will be based on what you have actually written down. At the same time, having the research done in a written form while actually presenting your case gives the option to the judge or the bench before which you are arguing to actually go through them at a later stage as well while passing a judgment, which is the normal practice that happens when you're actually arguing in court. At the basic level, a moot court is, in another sense, a mock court. It's not an actual law practice of litigation, but at the same time, since it prepares you for it and it helps you in your boosting of the CV as well, because having a moot on your CV or in general participating in moot courts prepares you not only professionally but also overall development of a student. And therefore, mooting in general is important, and we'll be going through the points of an actual moot memorial as we go further with the slides.
First and foremost, we'll be talking about the cover pitch. Now, the party who's approaching the court or who's approaching the tribunal or that particular bench generally has a blue cover pitch, and the opponent party, who's the opposing, supposedly the respondent or the defendant or whoever, has a red cover page in general. So now your cover page also has several aspects which you have to cover. First and foremost, at the top, you would have to mention the name of the competition that is conducting your moot competition. So then firstly, if you can see on the top, on the PPT that is being presented, on the left-hand side, where there's the memorial for the petitioners, you can see that I have written 13th National Moot Court Competition 2019. And under that, you have the team code. Now, for all moot courts, they have different rules and regulations which you have to follow. So this was with respect to the rules in accordance with the rules that were prescribed for this particular moot court competition. Other aspects include the forum before which you are presenting your case. So in this particular case, it was the Honorable Supreme Court of India. Now, generally, in your moot propositions, you would have the specific tribunal, forum, or the court mentioned in your moot proposition. But just in case it isn't, then you will have to figure which particular court or which particular bench or which particular tribunal has the jurisdiction where you are going to present your case. So that is why jurisdiction of the court plays a very vital part when you're writing your cover page. If that particular court does not have the jurisdiction, then your entire case goes for a toss. After that comes the names of the parties. Now, what is important here is the nomenclature. So, for example, if supposingly you are instituting a suit, in case of suit, the party who is instituting the suit is called the plaintiff, and the party against whom the suit is instituted is called the defendant. Similarly, in case of petition, say for example, a petition under Article 32 or under Article 226 of Constitution, the party who is instituting the proceedings is called the petitioner, and the party who has to present his defense is called the respondent. And in case of criminal proceedings, the party who is complaining or who is presenting his grievance is called the complainant, and the party who has to present his defense is called the accused. So the nomenclature that you have to write on the cover page is very important. You cannot write that this particular party who's instituting the suit is a plaintiff, and then for respondents, instead of respondents, you write accused, or that goes completely wrong. After the party, so the party who's presenting the case would be first, and versus the party who's opposing, against whom you're instituting the proceeding, the case, would be the respondent. Now in this case, because baby Q was a minor, basically not even into existence, that is why this particular case was instituted through her mother Anjali. Now after that, we come to the provision of law. So when you are approaching a particular bench or a particular court, you have to approach the court under a provision of law specified under various statutes. So for example, in this case, because it was a writ petition under article, it was a public interest litigation under Article 32 of the Constitution of India. Therefore, I have mentioned specifically at the bottom that this petition is under Article 32 of Constitution of India. Now, supposingly various statutes like you have Insolvency and Bankruptcy Code, you have the Company Law, they have special tribunals that are established under the Act. For example, the National Company Law Tribunal. So for disputes that are instituted under those, for disputes with respect to that particular act or enactment, you will have to mention. So for example, there's a dispute which relates to a company or which relates to insolvency and bankruptcy, then you'll have to approach the National Company Law Tribunal. So this particular provision of law which you mentioned is also important for the court to decide if it actually has the jurisdiction to try the case. Then after that, lastly, you mention if this is a pleading, written submissions on behalf of either the party who's instituting, that is the petitioner, or either the party who's opposing, that is the respondent. After this, you have the index, that is the table of contents. Now your index also should be in accordance with the Moot Court guidelines or rules that are prescribed. Now, this will just give you a brief idea of how the index should be. First and foremost, it should contain the serial number, then the title particulars, and the page numbers. Now, writing page numbers is important here because when you're actually presenting your case, when you're arguing a case, and if you want to directly refer to that page where you have that particular issue or sub-issue involved, it will help you in directly going to that page and mentioning it before the court that, see, this particular issue is covered on page, which gives the judge a direct insight that, oh, you know your case very well. And for this purpose, you mention the page numbers on the index. So the index will contain first, this is basically a gist of everything that you've written in your memorial. First, it will be list of abbreviations. Then index of authorities. Index of authorities is nothing but a list of judgments that you're relying on in support of your case. Then you have the statement of jurisdiction. Statement of jurisdiction, like I said, whether the court has the power or authority to try your case. Then you have statement of facts. This statement of facts should be crisp and concise. It should not be an entire replication of what your moot proposition is. Then you have arguments presented. Arguments presented would be basically the statement of issues. What are the issues that the court will have to address, that the parties will have to address, that the court will have to decide. After that, you have summary of arguments, which will be only a summary, a gist of all the arguments that you are going to present. And arguments in advance then would be detail of all the arguments that you are supposed to address the bench about. Now, these arguments are divided into sub-issues for the sake of convenience. And these sub-issues should also be listed in your table of contents. Then at last, finally, you have the prayers, that is the reliefs that you're seeking from court.
As Ruchi explained, basically each and every point of the index will be explained in further detail. So first comes your list of abbreviations. In this, it in basic sense means that every single acronym that you've actually used in your memorial, whether it be AIR or SEC for an actual judgment you've cited, or simply mentioning IPR for intellectual property rights, or if you're referring to arbitration, you mentioned about UNCITRAL rules, those acronyms should actually be explained in the entire full form that they actually exist in. And that is done in a list of abbreviations, which is put right at the outside of your moot court memorial itself. This is more like a key that you actually see in probably an encyclopedia or other things, where in brief, everything that is written as an acronym is explained further. There are two aspects that go into this. As Ruchi said at the outset, even for your cover page, you have to follow the rules and guidelines that actually exist for the moot court competition that you're currently participating in. In case the moot court rules and guidelines mentions that you should have a list of abbreviations, then of course, mandatorily you should put it in. In case it does not have it, you could still put it in for the simple purpose that it actually is explaining what you are basically stating. And at the same time, then within your memorial, you don't have to actually put the full form. You could, in short, put an acronym and then explain it in one page saying what those acronyms mean. For example, instead of writing intellectual property rights everywhere, you can just write IPR. Or for example, instead of writing, as we usually write, you write Honorable Supreme Court, Honorable High Court. You don't actually write the entire word honorable. You write HON''BLE. So those kind of things. Now it is understood as a law student that the bench that you're arguing before will obviously be knowing the full forms of these actual acronyms. But at the same time, it is important to put them there because you are supposed to present your case as if the person who's listening does not really know what you're speaking about, and be as detailed as you can to ensure that whatever you're saying gets across. So in that sense, you see, even in the abbreviations put on the screen right now, some are very basic, like and AIR, Andhra Pradesh. And at the bottom, you see a little bit more details ones like ICCPR, UDHR, ICMR. So ICMR and probably MTP or ICCPR are also well-known abbreviations, but at the same time, you should put them in just because that's how you're supposed to do it. And at the same time, you should make sure that you actually cover each and every abbreviation that is in your memorial. You shouldn't skip any of them. Now, moving on to the next point, which is the index of authorities. Now, index of authorities is, in basic terms, again, how during our school projects, we would have a bibliography at the end. This is the bibliography of your moot court memorial. In short, it means every research that you have actually done and which you have put into your memorial, which is not out of your own thought, as in you have cited something or you've referred to something and then explained it in your own words, that has to be cited for the simple purpose that even if you're doing a research paper, you cite whatever you've actually used so that there's no plagiarism. At the same time, here it is more for persuasive value. If you have an argument which you make, but if that argument is backed by a case law, you have to cite that case law simply to actually add persuasive value and show it as a precedent, which is the common practice to actually put your points across. Now, if you see what we've shared on screen, our index of authorities is actually divided in this particular moot, which we've used as a reference, into three parts. One you can see is that there are case laws written with their citation. Second heading is books referred to, which is at the bottom right corner of your screen, books referred. And third is the dynamic links. There could be further things like law commission reports you've referred to or further books you have referred to. In that sense, you can keep making further subdivisions. And one thing that should be there throughout your memorial, which definitely should be in a tabular form here, is that you should be consistent. For example, if you see the entire table of case laws, it is in one format. You have the case name and the citation for each and every one of them. For the books referred to, you have the name of the book with the author. It's not like one of them is written as name of the book author, the other is author and then book name. It should be in a consistent format. And also your dynamic links, as in whatever you've referred to actually get your memorial across, is something that you can put in. Now, something like this in an actual petition or suit or whatever you file in court in actual practice will not really be put in this format. You, in your synopsis, you have a simple line saying judgments referred to, in which more often than not you end up putting none at present and all at the time of hearing, because in an actual court practice you don't cite all your judgments or you do cite your judgments, sorry, you don't actually keep copies of your judgments with like the highlighted paragraphs as such in your plaint itself. That's done during the time of arguments. But here, since as it's mentioned also, you should include all reference material, classify them into different parts, and at the same time put everything that you are really using for your reference, for your arguments in one concise table. Now, there are two ways of basically making an index of authorities. You have to follow whatever's put in your rules and guidelines of that particular moot court competition itself. But in any case, there can be two ways. One is you put it in chronological order, as in the way it comes in your memorial. For example, if your first argument has SP Gupta versus Union of India as mentioned here, that comes first, and then you move so on and so forth. Or another way to do it is you put all the cases in alphabetical order, wherein you can actually identify. For example, if SP Gupta was put in alphabetical order, it would have been somewhere towards the bottom. But when you are referring to your index of other authorities, you know where S would relevantly be. So these are the two ways in which you could actually make your index of authorities. But as we are emphasizing again and again, you have to follow the rules and guidelines of the present moot court competition you are actually part of.
After the index of authorities, your memorial would contain statement of jurisdiction. Like I mentioned earlier, jurisdiction is nothing but the power or the authority of the court or the tribunal that you're approaching to try and entertain the case. So now in the statement of jurisdiction, you'll have to mention whether the bench has the jurisdiction to try or does not have the jurisdiction. Generally, the party who's approaching the court will say that this particular bench or court has jurisdiction to try and entertain this case, and the other party should deny technically, but not always, because there are times when you have to actually submit to the jurisdiction of the court, because you know for a fact that otherwise than this particular court, no other court has jurisdiction to try the case. Then after you state whether it has the jurisdiction or whether it does not have the jurisdiction, you will also need to mention in brief why does this court have the jurisdiction. So for that, you can take a provision of law as your for your assistance, or you can state the law. Actually, you can cite it out that, for example, in this memorial, we've approached the Supreme Court under Article 32 of Constitution of India. That is why we've just replicated Article 32 from the Constitution to say that, see, under Article 32, we actually are approaching the court because this court has jurisdiction and no other court has jurisdiction to try this case. Now, to state that what is jurisdiction, there are various types of jurisdiction. Say, for example, territorial jurisdiction, there is pecuniary jurisdiction. If you see sections 15 to 20 of the Code of Civil Procedure, there you will find why in case of an immovable property, when you're approaching the court with a dispute relating to an immovable property, one particular court within the territorial limits of which that property is situated will have the jurisdiction. Similarly, where a cause of action arises, say for example, the cause of action has arisen in Mumbai, that is why the High Court of Mumbai will have the jurisdiction to try the case. So this is with respect to the type of territorial jurisdiction. In case of pecuniary jurisdiction, say for example, recently there was an amendment in the competition in the Consumer Act that supposedly the state commission or the national commission has the power or the authority to try cases until a specified pecuniary limit. So if you go beyond that limit, then the higher forum will have the jurisdiction to try that. So jurisdiction should always be a preliminary issue which the court should decide first and foremost, because if the court does not have the jurisdiction to try your case, then the reliefs that you're asking for would obviously not be granted. Moving forward, after the jurisdiction, you mention about the statement of facts. Statement of facts is nothing but you will have to list down all the cases. You have to set out all the facts that are relevant and material to your case. So you only have to submit those cases which you think will help you in better putting forth your case. So firstly, you have to keep in mind that you do not have to actually replicate the entire moot proposition, because your moot rules will also have a page limit to how much your memorial should run into. So if you put the entire statement of facts, you would not have much place left to actually put your arguments, which are very crucial for your case. So first and foremost, you have to list down only those facts which are pivotal or vital for your case. Then in the statement of facts, you do not list out the legal submissions or the law that is involved. So facts are plainly facts. Now, facts, how do you identify whether this particular fact is material or not for your case? Now, for this, you have to understand there are some propositions which would favor the other side, and there would be some propositions which would be in your favor. So you have to be very smart when you pick and choose these facts and you present it before court. So also, while deciding any issue, the court has to look at facts first and then the law. Now, if there's a fact which prima facie is against you, then you do not use that fact in your statement of facts. That will be used. So basically, for moot court competitions, you are supposed to prepare for both the sides. So if you know that this particular fact would be used from the respondent side of point of view or from the defendant point of view, then you would put that particular fact in that memorial. But you should not use it for the memorial of the appellant or the petitioner. So this is all with respect to the statement of facts.
Just adding on one more point of statement of facts, as you see a moot problem, sometimes it could be a small 2-page problem, it could be a huge 60-page problem. And as you see in the sample that we've given, it's not actually really in a running paragraph as such. It could even be in pointer form where you're trying to portray your story. Now, moving further to the summary of arguments. Now, in this particular moot court competition that was there was one aspect which was not required as such in the rules and guidelines, which was just briefly stating each and every issue you have, as in either listing your issues or calling it your actual list of arguments. Which means, for example, over here in the slide that you see, there are 4 issues that have actually been identified and put as headings with a small little paragraph explaining that issue. Now, if you have a particular moot rules and guidelines which mention that you should have all your arguments listed, then what you see here as number 1, 2, 3, and 4 would actually be listed in one page just with the issues itself, listing down your issues in short. Now, summary of arguments, on the other hand, is listing the issue with a small paragraph explaining it. In this, you don't often see any case laws. Ideally, you should not be putting any judgments in this because it is just stating yes or no to the issue. As a very simple example, if an issue has XYZ committed murder, then the paragraph would state either yes, XYZ has committed the act of murder due to whatever reason, or no, XYZ has not committed murder due to the reasons given. You will not put case laws over here, or actually in that sense put a lot of law here. It is just a small summary which you will advance on in the next section known as arguments advanced. So over here, as you read, you have to in short list the issue, the short paragraph stating it either in affirmative or negative, and do not include judgments. Now moving on to the next part, which is the actual arguments advanced. Now over here, you have to actually expand on each and every argument. So to start off, I'm just going to go back to the last slide and show you point 1 again, which states, do Anjali Menon, ISK Fertility Clinic and Bluebell Hospital have locus standi? Now, this basically means there's an issue stating, do certain people have any locus to actually file the petition? This is your summary of arguments where you've put the issue and a paragraph. But in your arguments advanced, as you see, you will not verbatim copy the issue. You will actually state what your argument is. So here you see it says the 3 people have the locus standi. In case you feel they do not have the locus standi, which ideally in this case would be the respondent's memorial would state that, then you would have started off by saying XYZ do not have the locus standi. So your argument actually starts off in this section by stating what your argument is, and then you further move forward. Now, as you see in the slide also, at the outset, we have stated they have the locus standi. Then we've said, yes, they do. And then there's a subpoint put in. Over here, there is a particular subpoint. We've showed just one subpoint. The point of showing that is that you have to elaborate your arguments on each issue. While doing that, you can divide your arguments into further subpoints. For example, if there is one issue which you feel can be further divided into 4 subpoints because probably there are precedents of all 4 subpoints, or you can find law for each of the 4, then you can expand it further and explain it in that sense. So that shows you that you have to divide your arguments into sub-issues just for the purposes of further clarity, instead of actually keeping the entire issue, which could be answered in yes or no, which you've already done at the outset, and then expanding. Just dividing it further gives more clarity to you. It gives more clarity to the judge. And at the same time, a common practice to do this is so that when you are revising your memo, it's easier to remember. Instead of remembering 2 pages of paragraph written, you remember 2 pages which have 4 points with shorter paragraphs written, it becomes easier to actually understand. Now, if you see at the end, we have put one citation, which is put as a footnote. Now, this is basically to show, and going back to the point how we mentioned in the beginning also, that whatever you are referring to has to be cited and actually put as an authority and stated clearly. So over here, the use of citations is something that we've all been taught in law school. For example, here you see SP Gupta versus Union of India. Now, that is a case which you have written as a name, but what case that is, as in what the name is, what is the citation, has to be put at the end as a footnote, which over here is known as a citation. Citation and footnotes do have a little bit of a difference in that. But when it comes to your moot court memorial, it's counted as a citation because you're only stating the case with the citation. You're not actually putting a footnote where you're detailing the case out as well. One common aspect that you have to follow is that all of your citations should follow a similar style. For example, a common practice is if you're citing judgments, you put the judgment name and then you put the SEC or the AIR or whatever citation you've got. But the point is you follow for each and every judgment that you have the exact same standard format. You don't put one judgment with name and then citation and the next one with citation and then name. You will lose marks and it doesn't read consistently as well. Another aspect for arguments advanced and citations is using supra and ibid, which is our last point, which we've put in the text as well. This basically means citing something that has already been cited before. Now, supra is a Latin term meaning above, but does not mean immediately above. That is what ibid means. So, for example, if, as we've seen over here, SP Gupta is used as the citation. Say, for example, if number one citation is this case and the fourth one as well is the same case, then over here you would write supra at number one to basically explain that you are already citing the same thing, which is cited at number one itself. But in case the same case is in your second citation, then you would write ibid at one, which means it is just before at number one. That's the difference between supra and ibid. And moving further, just about your arguments advanced, over here, you should make sure not to actually recount your facts because that's done in the statement of facts and the bench is already well aware of the factual matrix of the problem. What you have to do here is answer how the facts is actually helping your case and how you are interpreting the facts to actually find out and give a detailed reasoning of why your case is actually strong and why your argument and the way you have interpreted the facts actually makes sense to the bench to actually convince them. And at the same time, of course, prove that the other side's arguments are weaker as compared to yours. So instead of actually recounting the facts to prove your point, you prove your point through the facts with the use of precedents, which means if you actually find the exact same factual matrix in some previous case law that has been decided by a bench, you put that inside because that gives you precedential value as well as gives you an authority to actually state that what you're saying is correct and has also been interpreted in the exact same manner by a previous bench. And that is the common practice even in actual courts in litigation, as we're all well aware of.
So in addition, when you actually are writing down your arguments advanced should be with respect to that particular issue. Now, to brief you all about what an issue is basically something that is asserted by one party and is denied by the other. So there may be issues of facts, issues of laws involved, which you have to address. Now, also with respect to the ranking of your sub-issues, these sub-issues should be ranked in a way that the first sub-issue that you're citing should grab the attention and should be your strongest sub-issue, your strongest argument, basically. So, like, for example, in this case, we've taken the first sub-issue to be the locus standi. Now, if the parties do not have the locus standi to institute a PIL, then your entire case will be dismissed in limine. That is why for the purposes of arguments advanced, you should also know how to rank your sub-issues or to rank your arguments. The last would be the prayers, that is the reliefs that you're asking from the bench. Now, when you're actually researching about what prayers or what reliefs are you going to ask from the court, you will also have to look at whether that particular court has the power to grant those reliefs. Now, to ensure that your prayers include all reliefs that you can ask for, you will actually have to research and put in a lot of thought as to what kind of prayers can you list or what kind of reliefs can you ask. Before going to the prayers or before researching about them, you have to be very clear about the facts that are involved and the arguments that you're presenting, because your prayers would be in line with the arguments that you're presenting. Now, the prayers can contain your main relief, and they can also contain several interim reliefs. Say, for example, where there's a suit with respect to a property, then your main relief would be with respect to that property, either possession or whatever. But your interim relief could be that until the final disposal or final hearing of this particular suit, you at least grant us an interim relief that you restrain the defendants or you restrain the other side from entering that particular property, or maybe you deposit some amount which is in line with or which is appropriating to that particular issue. So then firstly, when you're presenting your case, you should make sure that your case is presented in a way that you get your reliefs, that you get the prayers that you're asking for.
One basic point that we mentioned at the beginning is that you cannot go beyond the scope of what you've actually pleaded in your written submissions. Now, the reason why your prayer is so important is that mostly when you go for a moot court competition, the first line that everyone is taught is that if the bench is well versed with the facts, I'd like to move on to my prayers. So in short, that actually tells you that even the bench sitting there would ideally ask you, what are you praying for? And then actually start your arguments. So what you need to keep in mind is that in any case, when you revise your memorial for a competition, you would be knowing the entire thing, and you would be knowing your entire memorial, including which point is argued where, but make sure that the prayers that are actually listed out, verbatim. In case you are asked what is your second prayer, you shouldn't have to look at the prayer again to actually be able to state that sentence, because it does obviously look like you know your memorial completely if what you are praying for is at least something you know verbatim at the back of your head completely. And at the same time, as you see in prayers, we've listed number 1, 2, and 3, and then there's a line that says pass any other order, direction, or relief that may deem fit in the best interest of justice, fairness, equity, and good conscience. Now, this does not in any way go against the fact that what we stated about your prayer stating every relief you want. It just simply says that in addition to these 3 prayers, in addition to the arguments raised for these 3 prayers, if there is any other order or direction or relief that actually would be suitable to the case at hand, then the court will have the jurisdiction to pray for that, and we are actually requesting for it. It's important to state that so that the court is then not restricted to only what you've prayed for. By mentioning this line, you give the court the jurisdiction to actually state that in addition to what you've prayed for here, if there is something circumstantial to the exact same prayers, then they are able to grant you the same thing. And as you know, your prayers would obviously be completely opposite, whether you are on the arguing side or you're on the defending side. And that is how the prayers work. In short, if you are, for example, in our case, petitioner respondent, what petitioner will be praying for is something that the respondent will be opposing. And what the respondent prays for is something that the petitioner will be opposing. So that is why your prayer clause becomes important. It is something that is actually the most essential part of your entire pleading, which is why even in an actual court circumstance, if there is a plaint or a petition or a PIL or anything for that matter, your entire factual matrix is given, and at the end your prayer clauses are mentioned in very clear terms as to what you are actually seeking. And at the same time, you have to, of course, make sure, as Ruchi said, that your prayers are something that the court has the jurisdiction to grant you. You cannot pray for something which the court itself does not actually have the jurisdiction to grant you, or is not related to your case, or is not actually argued in your memorial itself. So that is something with respect to prayers and how you should be interpreting them and stating them in front of the bench. And the most important thing, or at least relevant thing, is that if, for example, you know what your prayer 1 is, you should be knowing which arguments, which issues actually refer to that prayer. So in case the bench asks you to state what your prayer 3 is and what your arguments are for it, you should know clearly for prayer 3 in specific, what are your arguments raised, what are the further points you've got, what are the precedents you've actually put in, and not confuse your arguments with respect to your prayers. Your arguments are elaborate, but your prayers are basically just one line. So it means that that prayer is actually explained by what you are seeking in your arguments to tell the court what you are actually seeking relief for and how you are seeking the relief by interpreting the facts in that manner. So this is how your prayer clause is actually stated. And just to add on a little further.
So when you are preparing a memo, you make sure that your memorial looks decently presented, because the marking schemes with respect to the memorials would be listed in either your moot court proposition or the brochure that you will be getting for the competition. So that is why it is very important to also beautify your memorial. After you're done with your basic research, you know what is the case from the petitioner side, what is the case from the respondent side. You also have to look at the font, the format, the style, the font size, everything. Because if it is not in line and if it is not presented in a way that looks decent or looks presentable, then that also sometimes the judges get a little irritated, because when it is not in line, when it is not presented in a way, they do not actually feel like looking at your memorial. And because your memorial contain marks, you should make sure that your, so for example, if you look at the table of contents, your table of each content from your table of contents, like the issues, the list of abbreviation should be on a different page. So this is how you present your memorial and make it look like you actually have worked on the case, and this pleadings you will, submissions you will be relying upon. That is why, in order for the judge also and for you to know where your content or where the issues are, where the arguments are, you have to present it in a way that will actually help you during your oral arguments.
It is most important to actually note that in a normal court setting, there is one petitioner and the respondents, as in there'll be one counsel arguing for them each. Here also it's the same thing, but you will be against 100 different people doing the exact same thing, which is where your memorial becomes important because of the marking scheme that exists. For example, if they say Times New Roman font 12, now if you use Times New Roman font 11, your arguments are still the same, your prayers are still the same, your entire factual matrix is the same, but you'll definitely lose marks for the competition purpose, which means it'll obviously be a hindrance to you moving forward. So those are rules and guidelines that you have to follow in totality, because even though it may seem that just one font size difference does not actually matter much, the point is that mooting in general is to actually prepare you for the world outside where you're properly practicing law. So if you can't actually follow the basic guidelines that are given, you definitely would be losing marks, and that is a very common practice. And the same thing goes with even simple things like actually having your prayer clauses or your arguments. If you see that all the photos that we've put up, if you notice, there are proper margins put at the side. So this in general is on a Word doc how you justify your font, wherein it comes as a proper paragraph and it doesn't look vague. As in the left margin and your right margin are both exactly the same. It's in one line. It reads better, and of course it helps in your marking criterias as well.
What students generally do is, in order to fit their arguments or in order to fit their entire memorial in the page limit that has been specified, they try to reduce the font or they try to reduce the line spacing, which looks shabby or shoddy. That is why, for you to come into that page limit, you have to make sure that your arguments or your sub issues that you're listing should be crisp. So when you're listing out your sub issues, you only have to state those particular points or the provision of law that is actually helpful. And then while presenting your case, that is while putting forth your oral submissions, you can elaborate them in detail. But your argument should contain one line, which then you can elaborate during the oral submissions. So you shouldn't be actually listing down the entire precedent or the entire judgment or the provision of law in your memorials. What you have to do is, you just have to keep one line, keep it short, crisp, and then when you're arguing, you're presenting your case, you can elaborate on that point. Because when you're actually arguing, like Yazad already mentioned, you cannot technically go beyond the pleadings or the written submissions that you have actually presented before the court. That is why it is very important that you don't put entire thing or your entire research in your memorial. Otherwise the other side also gets to know what you would be arguing orally. So in order for them to not know your entire line of arguments, it is important that you write only the important line, that is the punch line, in the memorial, and then later on while submitting to the bench, you can elaborate on that particular line.
And just one basic difference as such with respect to mooting and probably litigation in the real world is that, as you saw over here in your arguments advance, which is your main point in a memorial, we've basically said that as a practice, you should not be putting the entire, you shouldn't recount the facts as such entirely. It should be the facts interpreted by law, by precedent. Now, in your normal petition, for example, or plaint in High Court or Supreme Court or wherever you're actually practicing, there you will have an entire factual matrix given with grounds put and then prayers. And usually, up till the interim stage, at least for sure, you would be arguing the case based on the factual matrix of the matter. But in your moot court competition, you will be mostly asked about your arguments advance, because here it's preparing you to actually see whether you're able to research well, and then whether you're able to draft that same research in a proper concise format to put your point across. So in that sense, whatever you have actually written with respect to the memorial, as in the webinar is for drafting of the memorial, but in your moot court competition itself, along with your memorial, you obviously have to be able to speak your memorial. You have to know what is written in the memorial. You have to be able to say it in a manner in which it gets the point across. Because again, having it in written form is not enough. The bench sitting there is not going to probably read through your entire memorial word to word. They would be opening up pages which you actually mention. For example, if your arguments advance for issue 3 is on, say, page 17, you would mention whether the bench could please be kind enough to move to page 17. And in that sense, you would then go on about page 17. So it's important that you know where everything is. You know that everything is drafted properly. And for that reason, this webinar is to actually tell you how to draft the memorial so that you are ready with a proper memorial for actually arguing your case before the bench, which would then help you to do well in your moot court competition, basically.
Students also most of the times face difficulty in going about the researching part. So for researching, first you'll have to look at the law that is involved, or the act or the enactment that is involved. After you figure that out, when you're looking for precedents, when you're looking for case laws, you have online databases like you have Manupatra, you have SCC online, and I'm sure most of the colleges have subscriptions to all of those. So when you're looking for case laws, you don't have to read the entire case law. If the operative part, that is what the ratio decidendi, is relevant to your case, you can use it for the purpose of supporting your case. Now, how to actually go about? So when you are looking for a case law on, for example, Manupatra, there are case notes given. Even in case of Supreme Court, SCC online, there are case notes given. So if supposingly you find that case note relevant to your case, maybe the facts are not similar or identical to your case, but if what was held in that particular case is helpful for your case, you can obviously use that case law. So for researching, you will have a lot of books, you will have a lot of online sites that will be available, but you have to make sure that whatever you are citing or whatever you are referring to in your memorial should be very relevant to your, because you will have 1,000 books and so much content to actually include in your memorial. But since you have to make your memorial brief and short and concise, you will actually have to figure which case law would be the most relevant. Say, for example, if on one particular issue you have two case laws, one is from the High Court and one is from the Supreme Court, obviously you will cite the case law which is the judgment that is passed by the Supreme Court, because that holds more value. So that is why you should also know. And if supposedly there are concurrent judgments, that is, one Bombay High Court bench is passing a judgment and to the contrary there's another, say for example Karnataka High Court bench or any other High Court bench that is passing a judgment which is contrary to the one that has been previously passed, then you should be smart enough to actually include the Bombay High Court one in support of the case where you're, say for example, appellant. You should include the appellant, the judgment that is passed by the Bombay High Court in one memorial and the other one in the other, so that you can make use of your entire research in both the memorials and you are completely prepared for the case. So with respect to the value that a judgment holds, if supposedly a judgment is passed by the Supreme Court itself, there are two judgments passed on a particular issue, but one is passed by a bench of say 3 judges, one is passed by a bench of 5 judges. So then you would obviously cite that judgment which is passed by a 5 judges bench, because that will hold more value, and of course the later in time holds good. So if supposedly your judgment is passed in 2019 and there was previously a judgment passed in 2014, so your 2019 judgment overrules the 2014 judgment. Therefore, if you're relying on 2014 judgment, you'll be completely wrong there. That is why you should be updated with the judgments, you should be updated with the law. So when you're researching, you have to look at all the judgments relevant to one particular issue.
So that actually ends our presentation and discussion on the drafting of the moot memorials. If there are any questions or anything that anyone feels we've not addressed, then we'll be more than happy to do so.
Yazad and Ruchi, there are some participants, who have never participated in a moot court competition, and they have mooting as a part of their practical curriculum. So can you share with them, and colleges don't teach them. So can you share with them, like, what is the starting point and the list of steps? Like, you get a moot problem in front of you. So how do you start about it? Just in a nutshell, if possible.
Initially, whenever a moot problem is given to you, the first thing that you do is you read the moot problem, say twice, 5 times, 10 times, how much ever you want, because you will be in a situation where when you're preparing for the moot court, you will come across a new fact each passing day, which you will find it helpful for your particular case or in support of your case. So the moot proposition is very important in the sense that you should know all your facts in detail. You should know them by heart. That is, whenever a question is thrown at you by the bench, you should be able to answer with respect to the factual aspect. Of course, with respect to the law, if you are not, say, aware of that particular provision of law or that particular judgment, you can plead ignorance. But that you should do rarely when you're actually not aware of the judgment. But when you're actually trying to resolve a moot problem, the most important thing is your facts and the law with respect to your facts. That is why your research plays a very important role. So when you're researching, you try and research about all the relevant aspects or all the relevant areas of law which are connected to or pertinent to your moot court problem.
And also in general, if you're mooting for the first time, now most colleges at least have intra moots, wherein, as we stated at the beginning, mooting is technically so essential for a law student's development that each college actually has a mandatory intra moot which every student has to go through. So that obviously at the first time, or maybe in the first 2 times, you might actually be a little hesitant of how to start with your memo or how to even be able to read the entire factual matrix, considering the fact that the moot problem may be a little lengthy. So in that sense, the easiest way to approach it is to initially approach it as you are basically reading a simple story or a factual matrix, then going into it in a little more detail, trying to read between the lines and seeing if there is any other angle that the facts could portray, or trying to interpret the facts in a way in which you can actually prove a point from what is given to you. And a simple way to basically start with the drafting of your memo, if you have never done it before, is to first, as Ruchi said, first do all your research. First, find out each point, know the facts completely, know the actual memo, the moot problem properly, do your research on each point, find out which precedents would hold more value, and then you can subdivide your issues and actually put that into writing. Having everything ready with you from the beginning might actually help, for the simple aspect that then putting it down into a written format is a little easier as compared to being a little jumbled and trying to directly start writing. That is something which most students do make a mistake of. And as Ruchi said, the more you read your problem, or probably read it every day, you might find some facts which you've missed out on. And by starting to try and write directly or draft directly, you more often than not would actually miss out on some material facts of the matter.
Also, when you're after conducting your research, when you actually start drafting your memorial, you make sure that you're not using a lot of jargons, because you should try and keep it simple, because most of the times your opponent counsel, or if you put in a lot of jargons, then maybe your language would go vague and then there's a possibility that there'll be two interpretations or there'll be vague interpretations to what you actually want to submit, and that would not come out well. That is why you avoid using jargons. Of course, when there are Latin phrases or terminologies required, you must make use of them, but then you make sure that your arguments or your prayers or whatever submissions that you're giving to the court should be in a very simple legal language, not too technical and not too fancy.
Now the next question is, can you all share with the participants the importance of making notes?
So see, as we stated, the memorial is your written submission before the bench. Whatever you've stated in your memorial is something that you would argue. You should be knowing your memorial in totality as such when you do go for the competition. But of course, having a small little list where you've jotted down a few notes or even the arguments in brief for you to actually argue before the bench is very beneficial. For example, if I have a 20-page memo and my issue 3 is explained on page 17, I may not remember that, or I may look at the index of the memo and then open it. But if I have it jotted down on a piece of paper, or I have that argument itself actually jotted down in brief on the paper to make my starting remarks at least, it is something that is very beneficial. So you obviously would have to first make the memo as a whole, then make your notes based on that. And that is why we also stated during the arguments advanced to make it easier for yourself if you subdivide the topics, which basically means making it more concise. It helps. So definitely in that sense, having notes in an even more concise manner to help with your arguments will definitely help.
And notes would also be helpful when you're making use of judgments. So say, for example, for one particular sub issue or issue, you're using 2 or 3 judgments. Then you must be able to present to the judge, or at least tell him that which particular paragraph of the judgment that you're referring to. So when you're making use of judgments in the note, you can actually write down that paragraph so and so says this, and then when you're orally submitting, you can read that paragraph out. So in that sense, your notes must also contain the issue in brief, what you want to actually submit, and the relevant judgments. When you're referring to judgments, it should contain the paragraph and the page number where your relevant holding is there.
Yeah, my first question is, like when you spoke about the statement of facts, you all said that you'll have to put in the facts in a manner which is supporting your side, say it's petitioner side. But my question is, say for example, petitioner side, I've put the facts which are supporting me, but at the same time, I have some fact which is like saying that petitioner was at default at some point. So if it's actually not supporting my arguments, but if I don't put it, would it amount to concealment of facts or something?
No, it wouldn't amount to concealment of fact. Now, for this particular issue, I would like to say that when you're actually writing down your statement of facts, when we say that it should be in support of your case, doesn't mean that you exclude those facts which are, actually. So firstly, I'd like to say that you cannot assume facts which are not given in your moot court proposition unless you are given that liberty by your organizers. If you assume facts that are not specifically mentioned, your entire case can change materially. Therefore, if supposingly there is a fact which is going against you, then you mention that in short. You don't mention that elaborately, or you don't mention that in detail. Or if supposedly there are 4 to 5 lines or an entire paragraph about your defaults or default with respect to your particular case, then you just mention that this particular default was with respect to the petitioner or the respondent, whatever, but you don't mention the reasons that are mentioned in the moot proposition.
And my second question is, like we have certain memorials wherein one side is very strong, and like you have some landmark judgments which is absolutely in its support, and the second side is not very strong. So do you all have any experiences of such moots, and how do you deal with it, especially in your oral rounds?
Okay. See, now, since it is a moot court competition, it is known that there could be one side which actually has a little more beneficial case, as in the arguments are much stronger for sure. But that is something that the bench also ideally would be aware of. in the sense that the competition organizers probably would have made a problem that could actually be in that sense. But research is actually something that is unlimited. You could find some persuasive value in precedents, in arguments that you're trying to make. You could try to interpret the facts in a way in which you are actually portraying your case in a better manner. And at the same time, since it's a competition and it's not your actual court setting, the most important thing to know is that even in any competition you go for, you will get a chance to argue both sides of your case, as in you will always have two rounds. So it is understood that even in a situation where there is probably the petitioner with a more beneficial or strong case than the respondent, while everyone is arguing the petitioner round, they would obviously have that upper hand in that sense. But while everyone is arguing the respondent round, they would not. So there could be a marking criteria also in a way to show if there is not a strong case, how you manage to actually bring it out, or how you manage to at least counter the damage that could be caused to your case simply because you have a weak footing. And that is something which you have to actually be prepared for even when you're doing litigation in general, because every case won't be an open and shut case. More often than not, it's never an open and shut case, to be very honest, which is why it goes to a legal dispute and you have counsels arguing from both sides and advocates putting their minds to it, because there is a certain point in each and every factual aspect which could be interpreted in different ways. The law could be interpreted in a different way. The same exact statute could, be seen in one way, be seen in another way. There will be judgments also showing both ways. Of course, there would be a judgment at the end stating a particular thing because the other views would have been overruled. But in general, even if it's not the final ratio of the judgment, if there is persuasive value in it and it has been taken in a precedent, it is something that you could put forth to prove your case, even if it's a not that, like, if your case is not that strong. But at the end of the day, since you're going for the competition, you definitely have to put both memorials out. You have to argue both your sides. And that is something which, since you do get the chance to argue both sides, you wouldn't be in a worse off situation as such.
So my last question to you both is, for a student to be an avid mooter, any advice that, the fundamental areas of law that they need to focus on for successful mooting?
So see, to be very honest, I don't think there should be a specific area of law that they should focus on if they are still law students. Simply because if you do want to do litigation later on, or even if you're doing corporate or any form of legal practice for that matter, you will be dealing with a lot of different cases. And say if you're in the second year or third year of law school and you're probably beginning to moot, or deciding to do moots, if you're going to restrict yourself to a particular aspect of law, you won't even have that many competitions dealing with it. And at the basic level, when you actually do enter your college's moot court society, there'll be an entire induction round that you'll have to go through. And in that, you would definitely have some law which is not what you're probably preferring, but you definitely have to do it. And that is the point of generally researching in law and studying all the subjects that we do. You could definitely, as you finish one or two moots, you could choose your moots in a way in which probably, for example, if I like arbitration, I would like to do moots based on arbitration law. That is something which, if I've done a moot or two, I could then look for a moot of that particular topic. But at the outset, it's advisable not to try and restrict yourself to one particular type of law, because each moot court competition is different. You'll find research for every topic. There are case laws on each and every topic. The factual matrix, no matter what it actually explains, is something you will be able to explain in your own words as well, and interpret in a way in which you can put your point across. Whether it's a strong case, weak case, point of law you like, don't like, want to do, or do want to do, it's something that at the end of the day, the competition, if you've entered for, you have to go through that process. So as a general advice from the outset, I feel students should not personally be restricting themselves to a particular law point. But as they go forward, if they want to choose moots in a definite career path that they see, or point of law that they want to actually specialize in later on, that is an option which obviously they can avail.
So initially, when you're beginning to moot, I don't think students should restrict yourself or themselves to one specific area of law or to one specific aspect of law, because when you're doing moots, when you go about doing moots, you will get a hang of so many different areas of law that you would probably find an area of law which interests you. And then maybe you can, when you're actually going about your career, or when you're deciding about what field of law you want to practice in, then maybe all these mooting experiences would help you to figure out your particular interest. That is why when you're mooting, you should try out all different types of laws or all different areas of laws, which would in future help you to know your interest or where your actual comfort lies, basically.
And just to add on to that, in general sense, when we're studying each subject in law school, you're not taken into the entirety of the subject because you're studying it for one semester, and then in that sense, it's over. So any moot court competition you do, or for that matter, any paper you probably want to publish on a particular topic, that's the only time where you will actually delve deeper into the research on that topic and get a better understanding of it. So probably just because you don't like a particular subject in law school, for example, if you do not like studying IPR for that matter, but if you do a moot on IPR, now in IPR study, you will be studying copyright, trademarks, patents, GI as a whole in those 6 months. But your moot may be only on the topic of copyrights, which is not something that you would actually go into so much research in your semester you study it. But if you're mooting, as Ruchi said, you might actually develop an interest in it. So in that sense, you should definitely keep all options open. And because at the end of the day, the moot court competition is for your own professional as well as educational development. So you should not have a restriction as such at the outset.
I have two questions. What is the difference between the arguments and the drafting of moot memorials of the trial advocacy competitions and moot court competitions? And my second question is, whenever we are in a moot court, so how should we seek the permissions of the judges? Or like when we make some mistakes or when we don't know some things, so how should we address back that to the judges? Or if we want some time, so how should we ask that to the judges?
Okay, so now because this particular webinar was restricted to drafting of moot court memorials, that is why we did not stress upon how to actually submit to a bench or how to address the bench. Now, with respect to the permissions that you ask for, there are various, like before starting your arguments, when you know that when you are for the respondents, you say that if the honorable bench is well versed with the facts of the case, can we move forward to the contentions directly? Now, these courtroom etiquettes can be maybe taken in another webinar, or maybe, just to give you a brief, I'll highlight a few points. Like when you start your arguments or when you start presenting your case, you first have to ask for permission from the bench to address them as your lordships or ladyships. If the bench is comprising of a judge who's a lady and a judge who's male, guy, so then you have to address them as your lordships or their ladyships respectively. After that, when you start arguing the case, when you address them with respect to the arguments, if supposedly a question is thrown at you which you do not know or you're not aware of, you try to answer that question in brief, in consonance with the arguments that you actually have. But when you're completely blank about one particular question, you can plead ignorance. So you just say that counsel pleads ignorance to this, and if supposedly your co-team member is dealing with that particular issue, you can say that my co-team member will be dealing with this particular aspect of law.
And just to add on, for example, see now how much ever you do prepare for actually speaking, you could obviously falter during the actual competition. That's happened to all of us, and it's part and parcel of going through moot court competitions. For example, even in one of my moots, there was an issue which I was supposed to deal with, but while actually arguing the concept, I had forgotten the case law itself, which I had cited. So at that point, instead of, trying to state the case law, knowing very well that I have forgotten it or that I do not remember it in its exact sense, it's better not to actually portray something in a wrong sense and instead, stay silent or state that, another team member will be taking up that issue. Because of course, say for example, if there are 6 issues and there are 3 speakers, for example, you probably might divide them into 2 issues each. Now, even though you have divided it between your teammates, it doesn't mean that each teammate will only know those 2 issues. You will never do well in your moot court competitions if that's how you're actually going to go through the entire process. You should be knowing your entire case as a whole in totality. So the point is, in case you do fumble or you falter, there is always another speaker to back you up. And especially because it is a competition at the end of the day, you will be marked on how well you speak, how much you have actually been able to answer. So these things, keeping those aspects in mind, it's better to not state something wrong and keep quiet and let somebody else argue it. You do not lose marks, neither will you lose individual speaker marks or team marks for that. But definitely, if you state something wrong, your case will go for a toss. So at the end of the day, if you are not confident with what you are saying, that's completely okay. It happens to all of us. So that's perfectly fine.
Yeah, and for this purpose, like Yazad already mentioned, you should stay in constant touch with your team members. So, for example, you've divided your issues for the purposes of arguments, but it should not be that you are completely unaware of another issue that your team member is dealing with. Because at times there are problems that the issues are interconnected or interlinked, and there may be a question that is posed at you which you are supposed to know in respect to the issue that your team member is taking up. So you should not be completely alien to what the other arguments or what the other team member is talking about or is going to present. Therefore, to keep your arguments in line, you have to, also while researching, you have to be constantly in touch with your team members. You have to keep discussing your case over and over, so that when you're also drafting the memorial, it comes in a flow. It should not be that your first point, your first issue, you're talking about something, and then the second issue is entirely unrelated or unconnected with the first issue. That is why, to keep your arguments in a flow, you have to constantly keep discussing it with your teammates.
And just to add on, in your normal litigation practice, you might have a counsel arguing and the advocate standing on the side. So in case, for example, the counsel is missing out a point or there is something further that has to be added, the advocate will mention it, or the junior counsel would, or whoever in that sense. During your competition, you will be standing there at that podium alone. Your teammates will be sitting on one bench with the other teammates on other team at the other side. So in that sense, since you will be alone out there, you have to address the bench directly. Which is why if you falter, instead of stating something wrong, it's completely fine to state that your other teammate will take it up, because at that point, you don't get a chance to look at them and actually ask for the answer then. You could, and that is where even the previous question of why are notes important, it could help in this aspect as well. There is nobody stopping you, no one stopping your team from keeping all speakers' notes at the particular podium where you're going to be speaking from. So even in case there is a question asked on another issue which you're particularly not dealing with, you at least have the note there to help you answer that doubt. So in that sense, that is how you could actually argue your case in an effective manner.
And additionally, a note will also be important, because sometimes the judge will tell you that you wrap up your arguments in 5 minutes or you wrap up your arguments in 2 minutes. So from that note, you should be able to figure out which particular argument is most vital or most important for in support of your case, and you need to address the bench on that particular issue itself first, and then maybe later on, if you have time or if the judge allows you to speak on further, then maybe you can go on addressing with several other issues. That is why, for this particular purpose, preparing a note with judgments, paragraphs, issues is very important, which will help you at the time of oral submissions, because each team will also have a specified time limit for their particular oral submissions. Say, for example, your team gets 25 minutes and the opponent team gets 25 minutes. So you have to make sure that, and in amidst all of this, you will be also asked questions. So you have to make sure that your arguments completely cover everything that is included in your memorials, and your entire case is put forth in a way that the prayers, that the reliefs that you're seeking are actually granted to you.
And also, since we're talking about memorials and mooting in general, since it is basically for your education and professional development, one thing that is important is that through moot courts, you also learn the practice of the actual court craft and how to argue in court. Now, this comes in two ways. One is basically how to address the bench and put your case forward. And a second is also the tone and manner in which you actually put those points across. Now, for example, if the bench is constantly badgering you with questions, which happens very often in moot court competitions and also in court as well, if you start fumbling, or if your arguments go all over the place, or your tone changes, it may not be looked at as an effective argument, simply because of the fact that you've gone out of your comfort zone, even though you know the entire matter. The entire point of the bench questioning you in that way is so that you can make your case as strong as you can. And while doing this, in addition to actually portraying your facts, you should also know what way the other side might interpret their facts, might interpret the same facts to put across a completely different story. It's basically, in a sense, knowing how the entire game as such could be played, or how the facts could be twisted in a way to prove someone's point, even though the facts may not state it clearly, but just basically by interpreting it in a different manner, in addition to then having case laws to back it up, you can prove a weak case in a stronger manner. As one of the previous questions asked, what if one side's case is very strong and one side's case is weak? And Ruchi also touched upon the fact that in case some competitions allow you to also not, add facts as such, but assume facts in a way in which how the question or the problem would go, there the assumption that you could make is obviously relevant to what is given in front of you. But there are various ways in which you could interpret it. You could assume the facts to actually prove a point, even if it may not be very apparent. So that is something which does prepare you even for your work after you're done with law school.
So as I already mentioned earlier, when you're preparing for a moot, first make sure that you're aware, or you know your entire moot problem in detail before actually going about the research part. Then the second thing that you do is start researching, looking for case laws. And before that, I would not advise going about drafting of memorials, because before research, when you start drafting the memorials, it'll just take a lot of your time in going about the drafting, and also your draft or your arguments would be placed in a very haywire condition. That is why, in order to ensure that your arguments flow in line or are in order, you have to conduct your entire research before actually drafting of memorials. And moot courts will actually prepare you for your actual courts, because you would know how to address the court first, then you would know how to draft your pleadings, though not in totality, but you would know what facts to use, what law to use when you're actually drafting pleadings.
Yeah, just as a general advice also for everyone who's probably not done a moot before and is looking forward to do it, from personal experience, I could say that if you have an opportunity to do a moot, or for that matter, any extracurricular activity during your law school, you should take it up. Instead of being afraid and thinking I will do it later, or I'm not ready to do it now, if you actually try and make an attempt, because when you're in law school, you have all your batchmates, you have seniors, you have your professors, you have everyone and you have the internet at the end of the day from where you can get anything you want. So in that sense, making use of the opportunity is something that you should do. Personally, I also did not moot until I was in my third year, because I was afraid of actually doing a moot court. But once I did do it, I really enjoyed it. And then for my next 3 years of law school, I continuously did moots. So that is something which, in hindsight, if I had started from first year, I might have been able to do more moots or enjoy the process a bit more. So if you do have opportunities, and since there are obviously many students here who've never done a moot before and are skeptical about how they'll be able to go about it, I would say try and jump at the opportunity, because at the end of the day, you're not alone. You have a team with you. You have obviously a senior who will be helping you coach the team. You will have professors who you could speak to for research on that topic of the competition which you're going for. So you have a backup. And at the end of the day, you do have your own mind and ability to do the same. So in that sense, it should be a good option to take up mooting in general during law school, because it is something which will not only help you for later, but also help your CV at that present point and help your own development as well.
Thank you.
Thank
Thank
you.
you so much. Thank you,
Thank you.
everyone.